4, 3, 2, 1. Good morning and welcome to the South Carolina Public Service Commission. We are here today on a rulemaking proceeding 2025-191A. And after that, we're going to do 192A. Present in the hearing room is Commissioner Britt, Commissioner Caston, Commissioner Whitfield, Vice Chair Williams, and I am Chair Powers. Joining us virtually is Commissioner Belser and Commissioner Henley. I guess before we start, I would like to identify any parties that are here or virtual. And if we could start with Dominion Energy.
Good morning, Mr. Chairman and members of the Commission. My name is Chad Burgess, and with me today is Elizabeth Hutton. We are in-house corporate counsel for the company, and also present with us is Michael Anselmo from the law firm of McGuire Woods, who serves as the company's outside counsel. Thank you.
Duke Energy Carolinas LLC and Duke Energy Progress LLC.
Good morning, Chair Powers, members of the Commission, Tekla Henderson and Lyle Trawick on behalf of Duke Energy Carolinas and Duke Energy Progress.
Thank you very much. Office of Regulatory Staff.
Thank you, Mr. Chairman, members of the Commission. Ben Muschin on behalf of ORS.
Thank you very much. Is anyone online from the South Carolina Department of Consumer Affairs? Lockhart Power Company. South Carolina Public Service Authority, Santee Cooper. Southern Environmental Law Center. Nexus Water Company, South Carolina Utilities.
Good morning, Mr. Chairman. Charlie Terraney for the Nexus Utilities.
Thank you, Mr. Terraney. Palmetto Broadband Coalition. Walmart, Inc. Piedmont Natural Gas Company.
Good morning, Mr. Chair, members of the Commission. Jason Richardson of McGuire Woods LLP, representing Piedmont Natural Gas Company.
Thank you, Mr. Richardson. Carolina's Clean Energy Business Association. All right, I think that covers it.
Mr. Chair. Excuse me, Mr. Chair.
It's all yours.
Okay, thank you, Mr. Chair. Mr. Chair, thank you for allowing the Commission staff to make a presentation this morning regarding public witness testimony and customer public hearings in docket number 2025-192A. And before I begin the presentation, Mr. Chair, I'd ask if you would consider allowing certain jurisdictional documents to be marked for identification and entered into the record of this case. The first composite exhibit I'd like for you to consider as the first hearing exhibit contains documents from the Commission's docket management system, including the notice of drafting, which was processed in the docket management system on November 14, 2025, and the proposed regulation, which was processed in the docket management system on January 9, 2026, and verifications of the proposed regulation, which were published in the docket management system on January 13, 2026. And I've provided copies to the interested stakeholders who are present in the hearing room, Mr. Chair, and I'll provide copies now.
All right, is any objection to, all right. Then the DMS notice of drafting, proposed regulations, and verification is going to be in the record as exhibit number 1.
The second set of documents for your consideration as the next composite hearing exhibit, Mr. Chair, include the notice of drafting published in the State Register on November 28, 2025, the proposed regulation published in the State Register on January 23, 2026, including the text of the regulation, which is linked in the proposed regulation published in the State Register.
All right, the notice, proposed regulation, and verification as stated will be placed in the record as exhibit number 2, if there are no objections.
Okay, next, Mr. Chair, we're going to proceed with the slide deck for this case. I've provided those to our interested stakeholders, and Ms. Wessinger Hill is distributing those to the commissioners now, and the court reporter has a copy. Live stream team, would you please publish the document on the desktop? Thank you. So the page 2 of the slide deck, Mr. Chair, contains some information that I just talked to you about, the publication of the notice of drafting in the state register and publication of the proposed regulation in the state register, and that's included on the documents that I just handed you. The next slide contains a copy of Commission Order Number 2025-392. And on June 19th of last year, the Public Service Commission instructed the Chief Clerk to schedule workshops as necessary and to initiate a rulemaking related to customer public hearings. On July 10th, Mr. Chair and Commissioners, the Clerk's Office issued a notice of workshop. It scheduled the first workshop regarding public witness testimony and customer public hearings for Friday, August 22nd, 2025, beginning at 11 o'clock a.m., or at the conclusion of the workshop scheduled for docket number 2025-191A. And as part of that notice, the Commission staff included a proposed language for a regulation related to public witness testimony and customer public hearings. The staff's proposed language included citations from practices regarding public witness testimony, practices from the Virginia State Corporation Commission. It also included citations from the North Carolina Utilities Commission. But staff also incorporated some of the Commission's current procedures. For example, oftentimes public witnesses are instructed that their testimony is limited to 3 minutes. The pre-registration process that the Commission already or has been practicing for quite some time or using for some time, that was also included in the draft that the public received via notification on our docket management system in the notice on August 22nd. And we had as always in our workshops, awesome participation and feedback. On November 10th, well, actually on October 21st, the Clerk's Office issued a notice of follow-up workshop after take into consideration the comments that were received during the August 22nd, 2025 workshop. And so a notice of follow-up workshop was published on October 21st. The notice provided that a follow-up workshop will be held on November 10th. So that's the second bullet point there. And that notice included an updated draft regulation for consideration at the follow-up workshop. On December 2nd, 2025, the Clerk's Office published another draft document of the proposed regulation subsequent to the November 10th workshop. And then the next day, the Clerk's Office found some language that it thought should be clarified. So on December 3rd, we posted an additional draft document for the public's consideration. So the regulation number that we're asking you to consider this morning is Regulation 103-845.1. And the title of it would be Public Witness Testimony and Customer Public Hearings. And you have a copy of this regulation, Mr. Chair. It is in the second stack that I handed you, papers.
Yes, ma'am.
You'll see a document, Mr. Chair. I'll place this on the camera. Would you please point to the document camera, everyone? Thank you so much. So this document, Mr. Chair, is a part of the proposed regulation, but it looks like this, what I'm demonstrating here. But if you flip over, you'll see language that says text. Okay, so that's what we'll be reviewing now. The text of the proposed regulation. So I will state once again that some of the language that you see contains or includes the current practices of the Commission. For example, public witnesses may testify in 103-845.1B. Public witness testimony may be provided in person or virtually. That's the current practice of the commission. By law, under subsection C or section C, public witnesses shall not be considered a party to a proceeding. That's the law. The next one, D, public witnesses will be required to take an oath or attest to the truth of their testimony prior to giving testimony. E, also a current practice of the commission, if a public witness does not pre-register to testify at a customer public hearing or public hearing that is not scheduled to be heard in the commission's hearing room, the public witness must register his or her name on a sign-up sheet at the hearing room location prior to his or her testimony. The next section is true too. After calling the hearing to order, the chairman or presiding officer shall outline the procedure to be followed for testimony and shall establish hearing room decorum standards. I missed A, Mr. Chair, but we in our workshop discussions, I will note that we added some language there to clarify that a public witness must be a customer of the party that initiated the docket unless otherwise provided by law. For example, there are a couple of hearings that you have pending now where, or at least one where that doesn't necessarily involve a utility. So there may be times where a public witness who needs to testify or can testify before you is not a customer.
Ms. Boyd,
Yes, sir.
I just wanted to point out that I think council's been very gracious in the past, allowing certain witnesses to testify,
Yes, sir.
and I appreciate that, but I'm glad we're putting it down in black and white.
Yes, sir.
Jocelyn, may I ask a question?
Yes, ma'am.
I'm concerned, unless otherwise provided by law. I mean, that's not addressing necessarily the witnesses that come in. That just seems a little strange to me. I mean, it's not like a rate case where somebody needs to be a customer of the utility to provide information relevant to that type of proceeding, but in a citing application, there may not be customers, but there may be people impacted or interested.
Yes, ma'am. And that
I
was
don't understand unless otherwise provided by law.
okay. So
Because there's nothing in the statute that says about a public witness at those proceedings. I think that's got my concern.
okay. So I think if I read A, I read it as, and you may read it differently, Commissioner Belser. The rule would be you must be a customer of the party. You must be a customer. That's the rule. The exception is if the law says that you don't have to be a customer, that you have an interest in the proceeding and you should be afforded the right to testify. That's the way I'm reading this.
But can we point to a specific statute or regulation other than this one that says you don't have to be a customer in these proceedings? That's my concern when it says otherwise provided by law. I don't know that I can point to a specific statute or regulation. Or rule, is it a rule of evidence perhaps that they have to have relevant testimony? That's only my concern. I know what we are getting at, but my concern is we can't tell a person that says, I want to participate in this proceeding, where is the law that says I can or can't, other than this regulation?
Okay.
I'm trying to be difficult, just trying to
No,
make
I'm not.
sure
I'm
we're
trying
correct.
to. I guess I'm following Commissioner, but I'm not really.
And the parties may be able to help with this at some point too. All I'm saying is, if we say, unless otherwise provided by law, what law is providing for what we're saying?
We do have statutory parties.
Yeah, I think what Commissioner Belser
This
is.
is dealing with public witnesses, not statutory parties.
Ms. Boyd, can I?
Yes,
Mr. Chairman,
Yes.
just for clarity, Ms. Boyd, if I could ask you a
Sure.
question. In the past, that a public witness, now I'm gonna separate these just a second, rate case versus other matters, utility facility. But in the past, for a person to have standing, a public witness to have standing in a rate case, they always had to have been a customer of the applicant, of the company, in a rate matter.
Okay.
Now, what you're addressing here would be for a facility siting matter or another matter where a public witness may have standing or may have standing to testify.
That could be the case. I'm thinking also, for example, I can't recall the in totality of the law. And Mr. Mushing, excuse me for speaking over you. I'm trying to think of other examples. Our solar choice tariff proceeding. I think the commission there was an issue in that proceeding about who should be allowed to testify. So I think it's, and I cannot recall off the top of my head if the commission issued an order. Some of you may, and I can look that up while someone else is talking. So I think it could be a citing case. I think those solar choice, that one of those hearings lasted into the late hours of the evening. I don't think all of those persons who testified were customers. So I'm trying to think broader. I understand what Commissioner Belser is saying, and maybe there's another word. But I think the commission has already experienced thus far public witnesses who sought to testify before the commission since Act 62, who were not customers of the applicant. So we've already dealt with this issue. Maybe there's better wording, but the commission has already been confronted with this issue.
And let me just be straight. I'm not trying to say that folks that aren't customers can't testify in certain proceedings. I'm just concerned with this language.
Okay.
That says otherwise provided by law, and we can't give a statute that says, okay, you are not a customer, but this law said, or this reg, or this. I'm just concerned with the wording.
That's fine. Yeah, and I'm following now. It's just I know that we've had situations that were in recent times where that has not. I mean, that's not
in a citing case. In a citing case, a person may not be this is just one example. May not be a customer of if the utility is trying to put in a transmission line, but a landowner nearby would certainly have standing to testify. In my opinion.
Perhaps it could be narrowed down.
Could be impact.
Perhaps it could be narrowed down then to unless otherwise allowed, something along those lines by the chairman or the presiding officer of the proceeding. Because that's who ultimately allows a witness to testify during the proceeding.
Mr. Munchkin.
Yes, ma'am.
Mr. Munchkin was going to say something. Does he have a suggestion?
Well, I was trying to find it and I can't find it. My esteemed co-counsel or counsel may say, and I can see Lyle, he's going to chime in here too, so he may say what I'm getting ready to say. I think in Act 41, there was some language about citing cases, in particular about interested members of the public being able to speak. And maybe I'm not remembering that correctly, but that's what was in my head when we were going through the workshops.
Yeah, I think that's subpart 2 of 5833-140.
40.
Mr. Chairman, if I might.
Yes, please.
I think to address Commissioner Belser's concern, I think that was the intention, at least of the parties here. I can't speak for commission staff, but was to limit it to the actual ratepayers who are appearing at public hearings for rate cases. I think we were specifically intending to accept Citing Act proceedings. Now, is there a better way to phrase that, perhaps? But I think to what Mr. Richardson said, that's a good point. 5833-130, which is in the Citing Act, also discusses hearings and sort of sets parameters. But I think the design here would be, let's limit rate case customer public hearings consistent with Act 41, Section 2, which is codified as amended at 583140E. Which talks about, the commission may convene public hearings to allow public utility customers to address the commission as public witnesses without intervening. And so we want that, but we want them to be customers if they're talking about rate cases and not trying to find a way to insert other testimony into the record, because in that proceeding, you're sitting in a quasi judicial capacity, right? It's not in a legislative capacity necessarily. And so this doesn't need to be like a subcommittee hearing before the Senate. And so that's kind of what the intent was there. But for a Citing Act proceeding, to the point several others have made, yeah, you may have affected landowners, you may have public officials who want to weigh in and say how that affects their community, good, bad, or otherwise. And so the intent there, at least from the parties in collaborating to try to get that language, was, unless otherwise provided by law. So if Mr. Richardson has a statute, maybe we could, propose having that as an express exception. But I think I can say at least our intent was to accept Citing Act proceedings. Maybe we should be more direct on that instead of accepting cases arising under the utility facility and Citing Act.
If my understanding is, Commissioner Belson, you're seeking to have a statute or statutes cited there.
No. No, I just wanted to make sure there was one. I honestly did not recall the citing the Act 41 language, and that was my concern. Is there a statute? If somebody says, if we have a customer, we say, what law is going to allow me or not, or to come under this? I didn't remember that statute off the top of my head, so thank y'all for providing that. I just want to make sure there is some statute there that is being referenced by this, not specifically. I don't mind this as long as we know that, yes, there is that statute.
And Chair Powers, if I'm
Mr. Cass.
right, and to make sure I kind of follow all this, it sounds like, if I'm understanding everything correctly, that for a rate case in particular, the general feeling or thought is that it should be a customer involved in that rate case relative to the applicant. Other things, such as maybe citing, it could involve customers in that area or interested parties around that. So is it worth distinguishing rate case, customers only, and other potential items that the chair or whoever could include others other than customers? I'm looking right at you. You might
I thought
as well.
so. I just, I hear your point. I guess my concern for this particular one is if we're changing language, we may have to start all over. So if we're able to point to a statute now and get everybody comfortable with it, I feel like the language is broad enough to provide that protection. And look, we're saying we're not going to oppose, folks coming in and Citing Act proceedings. I mean, we reserve all objections to the substance of their testimony, but I think that's the intent sitting here today of what that language would encompass.
Understand. I guess while I have the mic and Ms. Board thinking about subparagraph B there, public witness testimony may be provided in person and virtually.
Yes, sir.
And I know further over, where we talk about when we can cancel
Yes, sir.
hearings, my first thought when I read that, forgetting that we can cancel later, was everyone shows up at Bluffton and there's no in-person customers there and they're all virtual. That would,
Well,
I guess that's something that crossed my mind, and perhaps we think that's covered in this potential for cancellation, but
well, we provide, for example, in some notices, I'll talk about past cases. We state whether there's availability for a person to testify in person or virtually. That's in the notice. That's in the notice that's issued for each case, whether the facilities will, whether or not the commission will receive in-person testimony or virtually in the portion of the notice that references the public witness testimony. Cites, it gives a date, time, and whether or not the testimony is in person or virtually. Yes, sir.
okay, so in the event that we have a hearing scheduled somewhere else, public hearing, and it's virtual or in person. And if the cutoff time says, I think a week before, we need
Sometimes
to
it is,
notify.
but sometimes we accommodate if we receive a later notification.
Right. I guess what I'm trying to guard against is that if before everyone shows up at some place out of town and there are no in-person customers or in-person customers that have signed up, I just don't want the possibility that we could all show up in Bluffton just for virtual calls.
Okay, so I'm gonna use a hypothetical. Let's say that they're in the hearing, customer public hearing, instead of Bluffton, it's in Myrtle Beach. Okay, so the notice that we issue because the location is not here at 101 Executive Center Drive, the location for the hearing is not here. The notice will state Street, Myrtle Beach, South Carolina, in that section of the notice, and it will alert the public as to whether they can testify in person or virtually. Now, in order for someone to participate virtually, either Ms. Knight or one of her coworkers will have to send that person a WebEx invitation, Commissioner. Also, if they pre-register, because you're talking, in order for that to happen, there has to have been communication with the commission prior to. Either number one, we're going to call them, or they will receive a WebEx link. Does that make sense? So we will know prior to going because there would have been a communication. The customer or public witness would have notified the commission that if they pre-register, that they want to appear virtually. And then we would instruct them at that time you can't, virtual is not an option unless you'd like to appear virtually when the commission conducts the hearing in Columbia. That's what you understand. So it's not, if it's a virtual, in person, we cannot forecast, we can't estimate. But virtual, we have to be able to, because there has to be communication regarding, if you want to testify via telephone, we need your telephone number and this is when we're going to call you. If you want to testify via WebEx or some other platform, we have to send them a link. So I wouldn't be nearly as concerned about virtual offsite, because there are other arrangements that are made behind the scenes to accommodate that. Now here in Columbia, that can easily happen. And we work and either call them or we send them a WebEx link. Yes, sir.
Okay.
Yes, sir.
Thank you, ma'am.
Thank you for that. Because that's the part that Ms. Wilson, Ms. Goodfellow, they all work on that. It's behind the scenes and most people aren't aware of that process.
Mr. Chair, if I might,
Yes.
Commissioner Casson just in that dialogue with Ms. Boyd was talking about sort of participation, and I think Ms. Boyd said that telephone participation. Some people used to participate by telephone. Actually, as you read B in the proposed changes in this reg, it is limited to in-person or virtually. I don't know if that was an inadvertent oversight, but as we read this version of the regulation, there would be no phone participation allowed. Not saying they shouldn't be. I'm just pointing out what I think the construction of the regulation is.
And that's just my,
Yeah.
that's mine, and virtually you're not here. So, because we call customers, but I understand.
I wonder if we could just in our Article 8 docket, maybe we
Right.
could define virtually to include
Yes.
telephone, so we
Yeah.
don't have to redo this.
Right.
I just didn't want that to slip through the cracks.
Yeah.
I'll flag that for our next workshop.
Okay.
Okay.
Thank you.
Mr. Chairman, if I could just say one more thing. This is for Commissioner Belsers. I just want to make sure I'm not telling her something wrong. I do seem to recall there's something in Act 41 about interested persons testifying. I may be conflating two different statutes, and so I just want to, I think it's in there, I just can't find it. So I at least just want to note that.
Thank you.
Attorney Mustin, are you referencing a section of Act 41 that's different than what Attorney Richardson referenced?
So I think Attorney Richardson referenced, what did you say, 120?
140.
That's
Sorry, 5833 140 subpart 2, which that relates specifically to citing act cases.
any person may make a limited appearance in the 60 days after the date given in the published notice. That's the one you're talking about?
Correct, yes.
That may be what I'm thinking of. I had in my head something different. So I'm not saying he's wrong. I just in my head, but in fairness, there were so many different changes during Act 41's as it went through the legislature. It is entirely possible that I am confusing two different things. So I didn't want to misrepresent something to the commission. I just wanted to be clear. That may be exactly what, and that may be enough to get over as otherwise allowed by law.
Understood. Just wanted to clarify for my purposes, because one thing I will say about limiting for rate case proceedings, limiting public testimony to ratepayers, I think will have a pretty significant impact on who testifies, because I think we've all experienced public hearings for rate cases where we get all sorts of testimony, some even amounting to public performances. In fact, in my opinion, by people who are not ratepayers. And so it seems, with the exception, there's only one. And so hopefully everyone's comfortable with that. Again, I have no interest in chilling the public's ability to testify, but I do understand the purpose of the regulation. And Commissioner Belzer, I hope you're satisfied with where we are.
Commissioner, I don't have Act 41 or my statute book in front of me. I'm going to be looking at that after the hearing. But the explanation makes sense. What's been provided thus far. I just want to confirm that.
Mr. Chairman, this is Charlie Turney.
Okay.
I don't want to be a flying appointment here, but the intent was always to exempt proceedings such as citing act proceedings. But I do think the right to testify in a citing act proceeding in a public hearing is implicit. I hate to do this, but 5833-140 speaks to limited appearances in citing act proceedings and says any person may make a limited appearance in the 60 days after the published notice is given. But it goes on to say that no person making a limited appearance shall be a party or shall have the right to present oral testimony, which is exactly what we're talking about. So, but the way I read the Citing Act, at least, there is a hearing that has to happen, and that is the merit. That's what we commonly call the merits hearing. And the commission always has the discretion to allow public testimony. But I personally can't find an explicit reference to public testimony in a citing case. I'm not saying it shouldn't happen. I think it should. And this is what we had in mind. But 5833-142 is not it. I think it's more that you've got the right to hear testimony in a public hearing, period. And in rate cases, now it is restricted to customer testimony, which has been this commission's past practice, I thought, and should continue to be. But it's Commissioner Belzer, I think we're talking about an implicit right, not an explicit right.
Well, I mean,
go ahead.
If I could, my only concern, and everybody that participated in the workshop may be on the same page. That, and I think I know where you're coming from. But what happens in 3 or 4 years, and somebody new pops up and says, "I want to know what specific law is referenced in this regulation that allows these for public witnesses," and I flipped to another page and I can't find the exact. I think it says otherwise provided by law. And what we're hearing right now is there is no specific statute or regulation other than what no specific that provides for this public witness, that it's more of the commission's practice to hear from interested persons, customers in a rate case, but landowners, affected landowners or adjacent landowners in a siting, or whatever else comes down the pike. When we get new statutes, like let's just talk about solar. When Act 62 passed, there were a lot of folks interested. They might not be customers of the utilities. They might they were interested in coming in and giving their side of why solar was important, why these things were important, and I think it helped greatly in the hearings. I just don't want this language. I don't want us to have to say, okay, you can testify because this language is in this statute or regulation, or maybe we go to the rules of evidence at that point.
Can we, Mr. Chair, when Commissioner Bell's finished. So I think we all have different views on it. I was looking at it from the position of the chair being responsible for who testifies, who's allowed to testify, the extent to which they're allowed to testify. But even if we don't want to use recent legislation like Act 62, Mr. Mushton may have mentioned this already, so excuse me if he did, or Act 41, 58.3.142 talks about limitation on appearance of members of the General Assembly. So I don't know that a member of the General Assembly, I'm a constituent, maybe they have the same service provider, so maybe they don't. But maybe that's one exception. I'm not sure. The utilities would have to say whether or not a member of the General Assembly, if it's electric utilities rate case, that more often than not that member is also no, it's not rate fixing. So it's anything other than that. No member shall appear in any rate mixing by representing a party. However, this section does not apply to any member of the General Assembly appearing as a witness. Okay, scratch that. That's not gonna work. But I think you mentioned members of the General Assembly, they're not administered the oath, but they do come and talk to the commission. So yeah. I don't know that there's a law that prohibits a member of the General Assembly from coming and having a few words when there is a case pending. I'm not aware of one, other than what's here, what's mentioned in 58.3.142. If I misstated what you were saying before, Mr. Mushton, I apologize.
No, I think in all candor, and I did not mean to take us off down this road, and I apologize for that. I do think I was thinking of an earlier version of 3309. I don't think that made it what it was in my head. I don't think made it into the final version. So I apologize for taking us off down that road. But
Mr. Chairman,
first, Ms. Wester Hill has pulled up a section that I think is the relevant one.
Yeah, and Mr. Mushton and Mr. Richardson, you hit the nail on the head with the statutory section. It's 58-3-140E, or maybe it was Lyle. I'm sorry.
Don't need the credit.
Okay. And Mr. Mushton, it does say that public witnesses may address the commission on issues related to customer service, utility operations, reliability, economic hardship, affordability, environmental concerns, or other matters that may affect them. So there is provision in the law as well. And then I believe Mr. Trini was also talking about 58-33-140 subpart 2 or subsection 2. That's the one that deals with the limitations on the 60 days. But there is provision in law for the commission to receive public witness testimony.
And that's 58-33-140E, because I
no,
think you
ma'am.
said
It is 58-3-140E.
Okay, thank you.
You're welcome.
Thank you, Ms. Westerhill.
Mr. Chairman, if I might.
Yes, sir.
That same provision that Ms. Wessinger-Hill was just looking at, I do want to note that it says may. Subsection E says may convene public hearings to allow public utility customers to address. So what the commission is doing here is formalizing a practice that generally has had, that a ratepayer must have standing to be able to talk. And so for rate cases, that makes sense. I think if you look at 58-33-140E, 130, it talks about hearings. And it says the testimony presented at the hearing may be presented orally or in writing, provided the commission may make rules designed to exclude repetitive, redundant, or irrelevant testimony. Then it has specific rules about expert testimony. And that's really the problem you run into at some of those Citing Act public customer hearings is it's not customers, it's folks coming in from these groups that are trying to, testify with a lot of affirmation in what they believe, but it's really, trying to get an expert testimony when they're not a party. But all that to say, the hearings there, I think can be viewed more broadly because it says that, the commission shall promptly fix a date for the commencement of a public hearing. It doesn't necessarily say with respect to customers. And I think Act 41 says you may convene for public utility customers. And so we're reading that as permissive, but for rate cases, you're formalizing a practice. That's what this regulation is doing without disturbing the ability of folks to come and present testimony in Citing Act proceedings. And so I think we can lean on the broader language in 5833-130 subsection 1, which isn't limited by the following subsections of 2 and 3 to allow that distinction with respect to Citing Act proceedings while maintaining the prohibition on rate case proceedings.
Thank you, sir.
Also, one last thing to Commissioner Belzer's point of the language in that subsection A. Commissioner Belzer, this will be active for a minimum of 5 years. If adopted by the General Assembly, it is conceivable that another statute might be passed by the General Assembly that addresses this topic. So having flexibility in this reg might be a good thing, so we don't have to revise it again. And then
I'm fine now.
Okay.
I'm fine now. It was just something that was a concern,
Yep.
but I didn't mean to take us down this rabbit hole, but it's helped me, so.
No, it's a good one. And then Vice Chair Williams talking about maybe changing the dynamic. I mean, I think Act 41 kind of did change that dynamic. And it also does align with the fact that our Supreme Court has said that standing is a threshold determination that must be made for every judicial proceeding to see if somebody can participate. And I think it'd be very difficult for a non-utility customer in a rate case to come in and argue and satisfy the elements of standing. So I think that by importing all this together, you're meeting all these various pieces you have to put together to allow participation.
One thing to address, and it may just be our procedure, is we're waiting until somebody's standing here to ask if they're a customer. Maybe that needs to be flushed out on a rate case whenever they sign up. I don't know. That's something to think about, but that doesn't change the statutory thing. Commissioner Brett.
Thank you, Mr. Chairman. And I don't think it's a rabbit hole that we're looking at right now. And I think this is a great timely discussion, not so much for the rate cases, but the citing acts. And because we got potentially 3 issues coming before us in the next few weeks. So the discussion is very, very helpful and very timely. So I appreciate all the time that Ms. Boyd and her team and all the parties that are here today have invested in this, because it will be very, I think, impactful.
Thank you, Commissioner Brett. And if Commissioner Belzer's happy, then let's move on.
Okay, Mr. Chair. The next section is G, which refers to pre-registered customers being called to testify first. And then they're called in order of registration on the sign-up sheet. The chairman or the presiding officer has the right to change the order of public witness testimony. Section F alerts the public that when you appear to testify, you state your name. The witness will state his or her name and address. And the chairman or presiding officer may limit the scope of the testimony, specified to matters in the notice of public hearing. Letter I, Section I, public witness may testify only on matters on which the public witness has personal knowledge. Section J, in order to afford each witness sufficient time to testify, the chairman may prevent cumulative, repetitive, irrelevant, or unnecessary testimony. And the chair or the presiding officer may establish time limits for testimony, by limiting the testimony to 3 minutes or less. Section K, at the discretion of the chairman or presiding officer, A public witness may submit his or her remarks in written form, but written testimony must be submitted at the time of the oral testimony at the public hearing. Also, at the discretion of the chair, a public witness may submit written testimony in lieu of oral testimony, but any written testimony must be submitted by the public witness during the customer public hearing and be subject to cross-examination. Section L, public witnesses may be asked questions by parties of record or the commissioners. All objections to public witness testimony may be reserved until the merits hearing before the commission. Failure to object to a public witness testimony does not constitute waiver of an objection to the public witness testimony. Section M relates to the commission's ability to, or right to cancel a public hearing that is in the community or one that's in the commission's hearing room. It also states that the commission decides if the commission cancels a customer public hearing, it will post notice of the cancellation at least 1 week prior to the date of the customer public hearing or public hearing that's not being held in the commission's hearing room. And if the commission cancels a public hearing here in the hearing room or one in the community, the customer or the public witness may testify at another public hearing, either in the commission's hearing room or one that's held in the community. Finally, if the commission cancels a hearing that is scheduled to hear public witness testimony or customer public witness testimony, the commission will use certain tools to notify the public of the cancellation, such as its website, the utilities website, the applicant's website, if the applicant is not a utility, press releases, social media posts, or other direct electronic communications with the customer or public witness.
Thank you. Any comments from any party or commissioner? Good.
That's all we have for this one, Mr. Chair.
All right. Thank you, ma'am.
Yes, sir. That's all I have. Unless you have more questions or comments.
So
that-
we got.
Yes, sir.
The next hearing will be at
10:30.
All right.
In a couple of minutes.
So as far as this one, we're adjourned.
Yes, sir.
All right.
Oh, Mr. Chair, normally you hold the record open a certain period of time to
All right.
receive additional comments.
5 days.
The record will be held open for 5 days. And thank you all very much. And I know there's been a lot of work done before we came up here to listen, and we appreciate it. We are adjourned.